organisasi yang melaksanakan fungsi-fungsi tersebut, yaitu Sekretariat Kementerian, Sekretariat Presiden, Sekretariat Wakil Presiden, Sekretariat Militer Presiden, Deputi Bidang Hukum dan Perundang-undangan, Deputi Bidang Administrasi dan Aparatur, dan Deputi Bidang Hubungan Kelembagaan dan Kemasyarakatan. Kemensetnek terus mengembangkan diri, menciptakan berbagai inovasi untuk menjadi kementerian modern, akuntabel, transparan, dan mampu menjadi solusi akan kebutuhan masyarakat. Segudang prestasi pun telah ditelurkan. Semua ini sebagai bukti bakti kami kepada negeri ini. Semua dimulai pada tanggal 17 Agustus 1945. Momen di mana mereka yang berbeda disatukan dalam Indonesia. Dengan semua kekayaan di dalamnya, Nusantara memproklamirkan pembentukan sebuah negara. Untuk menjalankan roda pemerintahan, pada tanggal 2 September 1945, Presiden Soekarno membentuk Kabinet Pemerintah Republik Indonesia pertama. Dalam peristiwa itulah diangkat seorang sekretaris negara dan juru bicara presiden. Sejak saat itu, Kementerian Sekretariat Negara tumbuh sebagai jawaban atas kompleksnya administrasi dan ketatanegaraan. Terletak di jantung kota Jakarta, Kementerian Sekretariat Negara memiliki posisi yang unik dan strategis. Secara garis besar, Kemensetnek bertugas menyelenggarakan dukungan teknis dan administrasi, serta analisis urusan pemerintahan di bidang kesekretariatan negara. Sederhananya, kementerian ini membantu Presiden dan Wakil Presiden dalam menyelenggarakan pemerintahan negara. Terdapat 7 satuan organisasi yang melaksanakan fungsi-fungsi tersebut, yaitu Sekretariat Kementerian, Sekretariat Presiden, Sekretariat Wakil Presiden, Sekretariat Militer Presiden, Deputi Bidang Hukum dan Perundang-undangan, Deputi Bidang Administrasi dan Aparatur, dan Deputi Bidang Hubungan Kelembagaan dan Kemasyarakatan. Kemensetnek terus mengembangkan diri, menciptakan berbagai inovasi untuk menjadi kementerian modern, akuntabel, transparan, dan mampu menjadi solusi akan kebutuhan masyarakat. Segudang prestasi pun telah ditelurkan. Semua ini sebagai bukti bakti kami kepada negeri ini. Semua dimulai pada tanggal 17 Agustus 1945. Momen di mana mereka yang berbeda disatukan dalam Indonesia. Dengan semua kekayaan di dalamnya, Nusantara memproklamirkan pembentukan sebuah negara. Untuk menjalankan roda pemerintahan, pada tanggal 2 September 1945, Presiden Soekarno membentuk Kabinet Pemerintah Republik Indonesia pertama. Dalam peristiwa itulah diangkat seorang sekretaris negara dan juru bicara presiden. Sejak saat itu, Kementerian Sekretariat Negara tumbuh sebagai jawaban atas kompleksnya administrasi dan ketatanegaraan.
3, 2, 1.
Assalamualaikum warahmatullahi wabarakatuh. Selamat sore, salam sejahtera bagi kita semua. Selamat datang Bapak dan Ibu, para peserta webinar on Data Protection and Sharing, Experience of Indonesian and UK Governments. Pada hari ini, Kamis tanggal 10 Desember tahun 2020. Webinar kita hari ini terselenggara atas kerjasama antara Kementerian Sekretariat Negara dengan British Embassy Jakarta. Saya, Yosita Sinintia Marsha, pembawa acara pada hari ini, mohon perkenan memandu acara ini dalam bahasa Indonesia dan bahasa Inggris. First of all, I would like to welcome His Excellency Mr. Owen Jenkins, the British Ambassador to Indonesia and Timor-Leste, and the Honorable Bapak Nicholas Teguh Budi Harjanto, Special Advisor to the Minister of State Secretary on political communication and organizational affairs. I would like to also address our speakers today, Mr. Dedi Permadi, Mr. Tony Richards, Mr. Joshua Sitompul, Ms. Karabora Juili, Mr. Steve Day, Mr. Charles Baird, and Mr. Raditya Kosasi. Last but not least, our moderators for today, Mr. Gogor Okonorhyoko and Mr. Angus Berry. Good afternoon, Pak Gogor, and good morning, Mr. Angus Berry. Today's webinar will be conducted in two panel sessions. The first panel will be hosted by Pak Gogor with the topic on the discourse around policy and regulation of data protection and sharing in both countries. And in second panel discussion will be moderated by Mr. Angus Berry with the topic on the best practices of beneficial data ownership both in Indonesia and in the UK. Baik, sebelum kita memulai acara hari ini, ada baiknya kami menyampaikan beberapa hal yang perlu diperhatikan oleh Bapak dan Ibu sekalian agar acara kita bisa berjalan dengan baik dan lancar. Pertama, mohon pastikan jaringan internet, mic dan kamera Bapak dan Ibu berfungsi dengan baik. Yang kedua, untuk experience yang lebih baik disarankan menggunakan komputer atau laptop. Selanjutnya, dalam sesi diskusi nanti, peserta dapat mengajukan pertanyaan kepada para narasumber melalui fitur Q&A pada aplikasi AHA Slide yang tautannya bisa Bapak dan Ibu lihat di layar. Moderator akan membacakan pertanyaan terpilih kepada para narasumber, dan bagi pertanyaan terpilih akan mendapatkan souvenir menarik dari kami. Yang terakhir, peserta harus mengisi formulir kehadiran dan evaluasi untuk mendapatkan e-sertifikat yang tautannya akan kami sampaikan melalui fitur chat Zoom webinar dan YouTube Diklat Kemensetnek di akhir acara. Jadi pastikan Bapak dan Ibu terus mengikuti kegiatan webinar ini sampai akhir nanti. Baik, our today's webinar is successfully held under the cooperation between the Government of the Republic of Indonesia and the Government of the United Kingdom. Well, marking this wonderful occasion, I would like to invite all of us to take some time and put our attention to opening remark from His Excellency Owen Jenkins, the British Ambassador to Indonesia and Timor-Leste, representing the Government of the United Kingdom. His Excellency, Mr. Ambassador, the time is yours.
Terima kasih banyak Mbak Tika. Dan saya mohon dimaklumi kalau saya berbicara dalam bahasa Inggris selama acara penting ini karena bahasa Indonesia saya mohon maaf belum selancar saya ingin. Thank you very much, moderator. And let me welcome in particular Bapak Nikolaus Teguh Budi Harjanto, Special Staff to His Excellency the Minister of the State Secretariat. We're delighted to have you with us. Thank you also to colleagues from the Ministry of Communications and Information Technology and to my colleagues from the Department for Culture, Media and Sport in the UK, as well as all of our other speakers today in what I think will be a really productive webinar. And I think it will be because data, which we're talking about today, is really the driving force now of the modern economies around the world. It fuels innovation in businesses, and it's been a lifeline during our current pandemic. And I think we're all doing things online which a year ago we would not have imagined were possible. And the very fact that governments like mine and the government of Indonesia, businesses, organizations, public services have been able over the last 9 months to share vital information quickly, efficiently and safely during the pandemic has not only saved lives, it's enabled us to work from home, it's enabled us to keep the economy running, and it's enabled us all to stay connected with our loved ones as we go through this period of unprecedented disruption. And as we hope we enter a period which will lead to recovery and safety, I think it's really important that we learn the lessons from the last period and hold on to what we've learned during this period. And this is why the United Kingdom places so much attention on data protection and data sharing. And that's why it's at the heart of so many of our overarching and emerging strategies. that includes the UK's first national data strategy, which was published in September this year. That strategy is a central part of my government's wider ambitions for a fast-growing digital sector in the UK, and a sector which is underpinned by public trust and confidence. We want the United Kingdom to be a nation of digital entrepreneurs, of innovators, of investors. We want it to be the best place in the world to start a digital business, as well as the safest place in the world to go online. All of this requires clear and reliable data protection standards, and it requires them to be in place at all times, as well as clear data sharing guidelines, including within government, which often holds much of the most sensitive data. And the UK's response to the global pandemic has really powerfully illustrated the potential benefits of data. Our understanding of the disease, our ability to support people, and the government's cooperation across borders, including with friends such as Indonesia, have all relied on the responsible and effective use and sharing of data. And indeed, data protection and sharing have never been more tested or more vital to our national and international efforts. But we do have a duty to do more, especially with the data which the government itself holds, which can be used and shared for the benefit of society. Individual transactions, whether that's applying for social security benefits, whether it's buying a house, whether it's simply online commerce, are more resilient when personal information can be shared from trusted sources, for example, in the form of a digital identity. And these ambitions, the ambitions to achieve those goals, underpin our national data strategy as we seek to embark on a radical transformation of how the government understands and unlocks the value of its own data to improve a range of public services and inform at scale the decisions that we take. And we hope that all of that can be underpinned by a cross-government approach driven from the centre, because this is not just a question for communications ministries or information ministries or technology ministries. These are questions which face all our departments across government. We also hope that we will be able to position the UK as a global champion of safe data use and sharing, and in so doing, encourage the international flow of information across borders. All of these issues are by their very nature international. Data and information does not stop at borders, and this is why the UK is so keen on strengthening our relationships with countries around the world on these important issues. Indeed, our digital access programme right here in Indonesia has already held best practice sharing sessions with the Ministry of Information and Communications Technology on data protection standards in the UK, as Indonesia, of course, prepares to vote and implement its own PDP bill imminently. Indonesia is an emerging digital economy with an extraordinary potential for success in all of the areas I've touched on. The number of internet users and mobile connections has significantly increased in recent years and is continuing to rise. Indonesia's expenditure on information and communication technology has become the largest in Southeast Asia. Its cloud and its data center services are the growth engines for the future when it comes to enterprise here in Indonesia. A consequence of that rapid development of the digital economy has been an unprecedented flow of personal data, accompanied by ever greater risks to the security of that data. And we're delighted to be working closely with our Indonesian friends and colleagues to share insights and exchange best practice on these challenging issues, but issues of huge potential. I believe that today's webinar provides us with another opportunity to move forward that ongoing conversation on data protection and data sharing. We look forward to continuing and enhancing our collaboration with the government of Indonesia on the shared challenges and the shared opportunities which we face together, which arise from data. And our digital access programme and the other facilities at this embassy stand ready to facilitate important exchanges such as today's between our two countries. Thank you very much.
Thank you very much. What a remarkable note from His Excellency. Thank you very much, Pak. Ladies and gentlemen, also joining us today The Honorable Bapak Nicholas Teguh Budi Harjanto, the Special Advisor to Minister of State Secretary on Political Communication and Organizational Affairs, who will be representing Bapak Pratikno, the Minister of State Secretary, to convey the opening remarks of this session. Bapak Diko, the time is yours.
Thank you. Good afternoon, Excellencies. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera, Om Swastiastu, Namo Buddhaya, Salam Kebajikan. His Excellency Awan Jenskins, it's a great pleasure to have you here, and also other colleagues, Tony Richards, Mas Dedi Bermadi from Special Staff to the Minister of Communication and Informatics, Charles Beard, Karabo, Rajualdi, Steve Day, and Bapak Joshua Sitompul. First of all, I would like to convey a message from Minister Pratikno, especially to Your Excellency, Mr. Owen Jenkins. Regretfully, Minister Pratikno could not join this webinar and could not open directly through this webinar session because he is accompanying Pak Presiden. As he mentioned so many times, I'm sure Your Excellency understand very well that Pak Pratikno has no schedule, actually, you know, because his schedule is tied to the President, so can change, you know, quite dynamically. So it's a pleasure to greet all of you to this webinar on data protection and sharing. And it's a great opportunity for all of us, especially in the Ministry of State Secretariat, to have this session as a part of our effort to improve our capacity and also understanding about data sharing and data protection. And even though in the Ministry of State Secretariat, we don't deal directly with data protection or data sharing function, but you know, since you know we help President to administer so many things and also to prepare for bill and regulations before signed, before submitted to the legislator, then it is a good opportunity for our staff to learn from the expertise and also from the development, especially in the UK. We are all very much aware that our digital and also data protection is very lagging in many sense, including in the regulation. We still don't have regulation that is comprehensive enough. As Ambassador Awan mentioned, our personal data protection bill has been postponed in the deliberation in the DPR. Maybe hopefully next year it can be finished for the deliberation, so that we will have a more or less a comprehensive data protection bill, unlike in the UK or in EU in general with this general data protection regulation, or like in the US, in which that the approach is a little bit different because they rely on industry-specific regulation. But here in Indonesia, we have only maybe Dedi from Ministry of Communication and Informatics can tell more, that we have only the ministerial regulation so far. And protection of data, especially personal data, we all agree that it's part of the protection of basic human rights. You know, this is, you know, in accordance with the Article 12 of the Universal Declarations of Human Rights. We also put this protection of personal data in our constitution, in this constitution. So that's why we will develop the ability and also capacity also to protect the data. And this webinar is a very timely as well, as Pak Jenkins mentioned before. This is not only about sharing, but we can also learn many good lessons, from how we handle many issues regarding our daily activities in the office, and also the data sharing, in general, and also in preparing for the future. Like, I think will be very challenging task, to administer the vaccination for the people for all over the world, and depending on the vaccine that we will use, some vaccine requires like 2 or 3 times, so it means that, the data of individual person who will get a vaccine is very important, and the security of the data and also sharing of the data will be also quite, important, since people will travel again maybe next year or in 2 years at least, because I'm sure every one of us is already wants to travel again like before. So data protection, data sharing will be very important in the post-COVID era, and we of course really want to get more perspective about like the UK first national data strategy. Maybe our colleagues in Indonesia can learn more about that, how the obstacles and what the prerequisites for the success of that kind of strategy. And other than that, we also face so many challenges in the digital world, regarding the data sharing, data protection, because the cyber attack, in the past maybe it was only done by individual person, but now there is also possible like more organized or even more like collectively concerted effort to disrupt, to make a problem with our data infrastructures and also data security. So I'm sure that all the challenges, regarding with the disruption or with the data distortion or with the deterioration of our infrastructure to handle the influx of daily data, the fast data. Now we experience so many fast data because with the IoT, the real time data can be gathered in a very massive way. But of course, there's always problem with our capacity to process and to store, or even to make all those data meaningful into a meaningful information. And that's a challenges also that we will have to deal in the future. And back to our post-COVID-19 world, I think what we will discuss in our webinar will be very useful. So to the webinar participants, I encourage you to use these events as an access, to explore as many as possible aspects regarding the protection of data from our UK government counterpart, and also experts, and to pay attention to the experiences, and so we can learn the best lessons, so that we can prepare and improve the Indonesian architecture of data protection and data sharing. So to our UK government counterparts, especially through Ambassador Jenkins, on behalf of the minister, I thank you again for your participation and also support for this webinar, and also other programs related to the improvement of our understanding about data protection, data sharing, as well as data governance. Because in the future, those things, will differentiate between many countries, the data ready country and the not so ready or the failed country. So hopefully this webinar will strengthening also our network of knowledge and further deepen our relationships, especially this year we already marked the 71st anniversary of UK and Indonesian government diplomatic relationships. So again, thank you, Ambassador Jenkins and other colleagues from the embassy and from UK government, as well as other experts in the UK. And without further ado, I would like to, on behalf of the Minister again, I would like to open this webinar, and hopefully we can continue our exchange ideas and sharing experiences to build a better data protection and data sharing architecture worldwide. Thank you.
Thank you, Bapak Niko, for the insightful remark. But before we commence to our main session, I would like to His Excellency Mr. Ambassador and Pak Niko to take a picture first to treasure our moment, Pak. I will count it, 3 and 2 and 1. Thank you very much, His Excellency and Pak Niko. Now let's proceed to the main activity of the day. Ladies and gentlemen, we are now approaching to our panel session with the topic Data Protection and Sharing, Experience of Indonesian and UK Governments. In this first session, we will have the opportunity to hear presentation from 3 excellent speakers and will be moderated by Bapak Gogor Okonurhayoko, the expert staff for the Minister of State Secretary on Politics, Defense, and Security. Without further ado, Bapak Gogor, the floor is yours.
Thank you, Yosita, for your introduction. Good afternoon to our participants from Indonesia, and good morning to those of you from the UK. Welcome to the first session of this webinar. And in this first session, we will deal with the discussion about the data protection and security, which will be shared between the experiences from Indonesia and our UK government counterparts. In the first speaker, we would like to invite our Honorable Pak Dedi Permadi, or I better say Dr. Dedi Permadi, or Pak Dedi, please. Pak Dedi is currently serving as Special Advisor to the Minister of Communication and Information Technology, and he has got his bachelor degree, he has got his PhD degree from Public Policy from Lee Kuan Yew Public Policy, National University of Singapore. And before serving as Special Advisor to the Minister of Communication and Information Technology, Pak Dedi was Chairman of the National Movement of Digital Literacy in Indonesia. And previously, he was Director of Center for Digital Society, Faculty of Social and Political Science of University of Gadjah Mada, Indonesia. So Pak Dedi is an expert and well-experienced person in dealing with data sharing and protection. And Pak Dedi will discuss on behalf of the Ministry of Communication and Information Technology about the latest development of how the Indonesian government is promoting the security and protection of our data exchange and transaction. So, Pak Dedi, you have 15 minutes for your presentation, and please, you may begin with your speech and presentation. Thank you. Pak Dedi, please.
Thank you so much, Pak Gogor, His Excellency On Jekins, the Ambassador of the United Kingdom to Indonesia, speakers, ladies and gentlemen. Let me begin by conveying our most profound appreciation to the United Kingdom and the Ministry of State Secretariat for arranging this important forum. It is an honor to be here today to give my 2 cents on the data protection and security knowledge sharing between Indonesia and UK. I wish to share Indonesia's view in personal data protection and the supporting regulations relevant to the promotion of effective data use. I hope this forum today will be a place for us to have a dialogue and discussion on issues touching upon the Industrial Revolution 4.0 and the digital transformation in Indonesia. Survey from Indonesia Internet Service Provider Association this year reported that Indonesia currently has 196.7 million active internet users, with the penetration level of 73.7% of our total population. This number shows a gradual increase of 25.5 million or 8.9% from last year. With such growth, Google, Temasek, and Bain, in its Internet Economy Report in 2020, predicted that digital economy in Indonesia will be valued for 124 billion by 2024. OECD, in its digital economy papers, as it refers to McKinsey's report, projected that by 2025, the international data flow will contribute 11 trillion US dollars to the global economy. Corresponding to the OECD projection, McKinsey also forecasts that by 2030, the data full artificial intelligence will contribute 3 trillion US dollars to the global economy as well. Electronic data governance, including personal data, is regulated under, first, Law number 11 of 2008 on electronic information and transaction, as lastly amended by Law number 19 of 2016 or EIT law. Second, Government Regulation number 71 of 2019 on electronic system and transaction provision. And third, Minister of Communication and Information Technology Regulation number 20 of 2016 on personal data protection in electronic system. The laws stipulate rights for personal data owner, obligation to electronic system provider processing personal data, as well as authorizing the ministry to oversee and impose sanction to violation on the provision of personal data processing. However, the current development of personal data processing in commercial and public sectors requires stronger and more comprehensive regulatory framework. There is a necessity to provide clear regulations on the protection of personal data in Indonesia regulatory regime that is currently scattered in 31 regulations. It is also important to be mindful of the need of educate Indonesian public on the urgency of personal data, as well as to anticipate the impact of data breach. These factors are that motivate the Indonesian government to draft the Personal Data Protection Law. Indonesia is taking the word of data as the new oil very seriously. Indonesia is currently accelerating the national data center integration and vision to be fully operational by 2024. The operation of National Data Center will support the realization of Indonesia One Data Initiative or Inisiatif Satu Data Indonesia and electronic-based government system or sistem pemerintahan berbasis elektronik policy. These policies are expected to allow the Indonesian government to perform big data analysis to support a variety of its decision-making activities and provide better public services through the development of government super apps for intra-government activities, as well as government to public-facing service activities. At present, the implementation of One Data Initiative and e-government system are at the policy and mechanism making level. The ministry is currently in the process of completing required preparatory work. These policies are expected to merge 27,400 e-government applications in 630 institutions into 50 applications and 50 data centers with processor capacity of 43,000 cores and storage capacity of 72 petabytes. It will later be expected to ensure a heightened security for government data, consolidated data, and achieving data sovereignty. On the international cooperation, Indonesia has actively participated in the discussion on cross-border data flow. At various of international platforms, Indonesia has proposed three main issues on the matter of cross-border data flow, namely, first, any effort to establish cross-border data flow must emphasize on the data protection and data privacy. Second, calling international community to adopt common definition of data free flow with trust. Third, adoption of reciprocity, transparency, lawfulness, and fairness principle while maintaining adherence to countries' legal framework in cross-border data flow activities. Indonesia believes through these propositions, an optimal, safe, and secure cross-border data flow for later followed by data processing activities may be achieved. On a final note, with the massive use of digital technology, we have enormous potential. However, at the same time, there are also many challenges ahead. We have a lot of work to do, but together we can work faster and better. I thank you for the opportunity. I look forward to our collaboration efforts to promote safer and more efficient use of data to accomplish a highly connected global society that is just, prosperous, safe, and sustainable. Thank you very much.
Thank you very much, Pak Dedi, for your very clear and enlightening presentation and speech. So apparently we have got more better issues about data protection, and we certainly have a bright and future picture about how Indonesian government is putting its attention and all efforts to protect the data transaction and exchanges. Now, distinguished participants, we move to the second speakers of our first session of today. We have got here Dr. Joshua Sitompul, or Pak Joshua. Pak Joshua is representing the Director General of Information Application from the Ministry of Informatics and Information from the Ministry of Communication and Information Technology. Pak Joshua will discuss about the, sorry, I have to read down this. We'll discuss about Indonesia present and future regulatory framework on personal data protection. This is very hot and very important issues that we are dealing with in the past and also in the present and as well as in the future. Now, before Pak Joshua start with his speech and presentation, please allow me to read down his CV. Pak Joshua is currently serving as Coordinator of Legal Affairs in Application Informatics from the Ministry of Communication and Information Technology. Pak Joshua has got his PhD from Maastricht University in the Netherlands, and before serving in this current position, he was head of division of Indonesia's cyber law community. So we are sure that Pak Joshua is prominent and important figure in talking about these very, very important topics. So Pak Dr. Joshua, please, we like to hear about your experiences and your knowledge about the protection and regulation and law about data protection. Please, Pak Joshua, you have 15 minutes for your presentation. Thank you.
Thank you, Pak Nuhayoko. Good afternoon for everyone. Firstly, allow me to express my highest appreciation for the UK's government and Kementerian Sekretariat Negara for co-hosting this important webinar, which serves as a knowledge sharing platform between both countries on data privacy and data protection, particularly on best practice. Secondly, I would like to forward Pak Samuel Pangarapan's sincere apology because due to his tight schedule, Pak Samuel could not attend in this very important webinar. Today, I hope you could see the presentation. I would like to share regarding the recent government policy on personal data protection. So, as we know, in cyberspace, we live in a very hyper connected world. Every gadget, every device are interconnected, and we live in the virtual and ubiquitous world where transaction or communication can be done very fast. And in cyberspace, all our activities and identities is a manifestation of combination of 0 and 1. And in that regard, it reflects our personal data. Personal data of us are everywhere. In dealing with protecting personal data, as we know, there are several regional instruments that have dealt with personal data protection, and there are basically two approaches in dealing with personal data protection. The first is one legal framework that emphasizes on protecting constitutional or fundamental rights, and the second one is on boosting trade and economy. But despite of the emphasis of these approaches, the two approaches agree the need for cross-border flow of personal data. So in dealing with personal data protection or data privacy, several regional instruments have provided principles. And as we see, APEC has its own principles, ASEAN, GDPR, and also OECD. So, for example, APEC has 9 principles: preventing harm, notice, collection limitations, use of personal information, choice, integrity, and also accountability. ASEAN also emphasized on consent, notification, and proposals, accuracy, personal data, security safeguards, transfer to another country or territory, retention, and accountability. GDPR also has its principles: lawfulness, fairness, and transparency, proposed limitation, data minimization, accuracy, storage limitation, integrity, and confidentiality. And OECD, collection limitation, data quality, proposed specification, use limitation, security safeguards, openness principles, individual participation, and accountability. Although they have different emphasis on principles, some of them may share the same principles, For example, regarding the collection limitations or accountability in APEC, also shared in ASEAN and also GDPR. So within these different regional frameworks on protecting personal data, some instruments try to bridge the gap between the difference of principles and practice in dealing with data privacy or personal data protection. So for example, in APEC, there's a CBPR, and in EU, before the GDPR, there's a referential between EU standard and also APEC standard. So in dealing with those regional instruments, Indonesia has the interest to ensure how the state could protect the personal data of its citizens. And dealing with the regulation, the government and also scholars have tried to find the root in constitution in protecting personal data. So basically in Article 28G, many scholars and also in several regulations already recognize that the right to privacy and the right to personal data protection emanates from this article, even though the article does not explicitly say the right to privacy and the right to personal data protection. So it's quite different with EU fundamental rights that provide these two rights. Dealing with the circumstance in Indonesia, there are more than 30 primary legislations and secondary legislation that contain personal data provisions. And the regulating of the personal data is based on sector and quite partial. So there's a need to make comprehensive regarding the principles and also the obligations and the responsibilities of parties that related to the personal data protection. Electronic information transaction, telecommunication law, banking, capital markets, trade, health, civil administration have their own provisions regarding data privacy or data secrecy or personal data protection. And based on this partial regulation, the government and also now the parliament try to harmonize the existing legislation to make a comprehensive system on personal data protection. So first of all, within the bill, there's a pronouncement in the consideration part that the protection of personal data is a manifestation of protection of human rights, particularly on the protection of personal life. So based on the previous slides, we can see two approaches that accepted worldwide, and Indonesia tried to use the approach to protect human rights or fundamental rights in protecting personal data. So in that regard, the bill tried to establish the link between the right to personal data protection and constitution. It means the constitutional rights requires constitutional safeguards. So based on this approach, there's a progressive and comprehensive personal data protection system. If we see the aspects on legal basis, principles in personal data protection, data controller and data processor, and rights obligations of data subjects, there's a progressive regulation from Government Regulation 82, 2012 to Ministerial Regulation 2016 and Government Regulation 71, 2019, and now the Bill of Personal Data Protection. So regarding the legal basis, on the existing regulations, consent is the primary legal basis. But after Government Regulation 71, the government already accommodate other legal basis, such as performance of a contract, legal obligation, vital interest, public interest, legitimate interests. So these legal basis from Government Regulation 71 are also accommodated in PDP bill in Indonesia. There are some principles processing personal data that regulated in the Bill of Personal Data Protection, and basically these principles and also the legal basis in processing personal data try to accommodate GDPR principles and also regulations. For example, within the PDP bill, personal data is processed limitedly, specifically, validly, and transparently, processed pursuant to the purpose of the processing, processed in accurate, complete, not misleading, up-to-date, and accountable manner, and to the end, the processing of personal data can be evidently proven, which accommodates the principles of accountability. Also in PDP bill, the personal data protection scope encompasses from collection, analysis, transfer, disclosure, erasure from A to Z. So in this regard, data controller or data processors have more responsibilities to ensure that the processing of personal data is comply with the law. Data subjects' rights are regarded as a data controller or data processor's obligations. For example, regarding the data subject's rights to give and withdraw consent, it will be a data controller's obligation to obtain consent and discontinue the processing when the data subjects withdraw the consent. Data subject has the right to access his or her personal data, and the data controllers also has the obligation to provide access, rectify inaccurate personal data, restrict the processing, and there are some other obligations that the data controller has to conduct. For example, the obligation to have impact assessment regarding the scope and the risk in processing personal data. The bill also has several restrictions of rights. The rights of data subjects can be restricted for the purpose of national defense, security, law enforcement, public interest in the scope of state administration, supervision interest in the sector of financial services, and the restrictions is carried out only for the implementation of particular acts. Now, what is not regulated explicitly in the bill is that on how or what parameters of restrictions. So there are some parameters that can be used to restrict the rights of data subjects. For example, in APEC privacy framework, there are two elements, limited and proportional, made known to the public in accordance with the law, or based on the EU Directive 2016/680 regarding laid down by law, constitute a necessary and proportionate measure, and due regard for fundamental rights and legitimate interest of the natural person concerned. So probably in the discussion of the bill between the government and the parliament, this restriction could be adopted or adjusted according to the legal system of Indonesia. So there are some hot issues that's still ongoing in the parliament regarding categories of personal data, data protection authority, dispute settlement mechanisms, transfer of personal data, and criminal provisions. So for example, regarding categories of personal data, the bill separate between general personal data, full name, gender, nationality, religion, and specific or sensitive, sexual orientation, political view, and criminal record. But some parties or stakeholders concerned whether religion should be regarded as general personal data, or other stakeholders concerned whether sexual orientation should be considered as sensitive personal data. And hopefully the discussion in the parliament and the government could harmonize these opposite views and try to accommodate to the best interest of Indonesian subjects.
Excuse me, Pak Joshua, you have 3 minutes left.
Yes. Regarding the protection of authority, so data protection authority should be independent, free from external influence, sufficient authorities to supervise and enforce, sufficient financial, human, and technical resources. But the problem is whether this data protection authority should rest in the government institution, or it should be a new body or a new commission or a new institution to ensure that these elements could be preserved. Dispute settlement mechanisms within the bill, there are several mechanisms: arbitration, institution, court, or other alternative disputes. Some say it's good because it provides various mechanisms, but other stakeholders concerned whether this would give legal certainty on how a dispute could be settled. Regarding the transfer of personal data, it is one of hot issues in the bill, because there are several mechanisms that the government and also the parliament should harmonize how Indonesia would transfer personal data to other countries or to other institutions outside Indonesian jurisdiction. And criminal provisions, last but not least, it also based on the focus whether the imprisonment or fine is fair regarding to the criminal act that prescribed in the bill. So I think that's conclude my presentation. Thank you for your attention.
Thank you very much, Pak Joshua, for your very clear and very interesting presentation and speech. Distinguished participants, we have heard about the almost the entire law and regulation that has been or will be imposed by Indonesian government to protect and to ensure the safety of data exchange and data transaction. Now we move to the third session, the third speaker, that we will learn about the experience for our UK counterparts. So in this case, please allow me to invite Mr. Tony Richards. He is Standards and Assurance Lead from UK Government Digital Services, and he will discuss and will explain, and he will show us about the UK Data Protection and Security Regulation, including the Data Protection Act, General Data Protection Regulation, and broader policy to encourage data security in the UK economy. Before Mr. Richard will start with his speech and presentation, please allow me to read down his short CV. Mr. Richard is an experienced digital professional. He has a wide range of experience in high-profile government initiatives, both nationally and internationally, especially in the field of digital delivery, digital engagement, and policy analysis. He holds Master of Science degree in Public Policy and Philosophy from London School of Economics and Political Science. Mr. Richard, please, you have 15 minutes to share your knowledge and experience with us today. Please, time is yours. Mr. Richard.
Thank you, Gogo, and thank you everyone for your presentations today. It's been very insightful and very interesting to hear, and particularly the previous one that Joshua shared on your own data protection regulations. So what I'm going to do today is take you through some of the data protection law in the UK. And first I'm going to start with a bit of background. So the policy team responsible for GDPR in the UK, which is our data protection regulation, sends their apologies, but it is something that I can talk about nonetheless, given its importance to us as a government digital service. We put a high premium on data, and there's been a lot of talk today about the importance of data as an asset and the importance of data as a key thing to users and government everywhere. And we make it very clear that the use of data and the better use of data is an absolutely key requirement of any government service and in government digital service through our technology code of practice, which as the standards and assurance lead, I'm sort of responsible for advocating in my role within the Global Digital Marketplace Programme. it mandates the use of applying data protection law and applying it effectively as part of good practice for data sharing. And I think that is where it is absolutely key to start talking about this, and the user trust that we are trying to build. In GDS, we talk a lot about users and building trust with our users, and having good data protection laws which ensure user privacy is an absolutely key part of that. So data protection law in the UK has been around since the 1980s, but the law that has been cited, was just cited by Joshua, and most of you will know about, is the General Data Protection Regulation, or GDPR, which came into force in 2018 and remains a key part of the landscape. And it takes the principles of data protection around user privacy and user rights, and really codifies them and solidifies them, and really enhances principles such as consent, which I'm going to talk about in a second. And so what are the principles of GDPR, which came into force in 2018? So all data must be lawfully processed. It's got to be collected for its intended purpose. So you can't just collect data for one thing and then and tell the user you're going to collect the data for this, and then tell the user or citizen, oh, actually, I'm going to do this other thing. You have to be clear with that person what the data is being used for. You've got to have a high level of data accuracy, and users are allowed to hold you to account for that accuracy. And you've got to hold data for no longer than is actually absolutely necessary for the purpose you told the user that it is required for. And of course, you must handle it securely. So you mustn't handle it in a way which could be compromised by hackers or any such like. The other key aspect of this law is that every organization, whether it's a public sector organization or a private sector organization, whether it's government or private business, must have a data controller. And this is the person who ensures that the whole organization meets GDPR regulations. So if you as a data processor are processing someone's data, if let's say you're an administrator and you're processing an individual's data, you must consult with the data controller to ensure that what you're doing is compliant with GDPR. I think it's worth talking about GDPR and what it does for user trust. A lot of talk about GDPR is this core guiding principle of privacy by design. And with privacy by design, what we mean is that when you build database services, privacy must be an absolutely integral part of those kind of services. And to summarize what GDPR does in that respect is it creates privacy rights, it enshrines them in law, and it gives people rights to access their data, to object to the way it's processed if it's not being processed for a legitimate reason, or seek for it to be changed if it's not accurate, or even erased if the legitimate aim for processing it has ceased. And it's worth us being clear here as to what kind of data we're talking about. This is personal data. This is data which could identify an individual, such as a name, an email address, or anything that could be used in conjunction with other data to directly identify one individual. That's what we mean by the kind of data we're talking about here. And therefore, the personal data gives those persons individual, what we call data subject rights. So they have a right to be informed about how their data is going to be shared. They have a right to access that data being held on them. They have a right to rectification. So if the data is inaccurate, they have a right to call that out and say, could you please change the data on your database because it's not right. They have a right to ensure that the data is erased if it is no longer needed for the use that it was originally intended. So if the purpose of the data being processed has ceased, they're allowed to ask that organization for erasure. They also have the right to restrict processing of that data if their consent has been withdrawn or the legal aim has ended. They also have a right to data portability. So that links with the second point about access. So people have the right to say, I want my data in a machine readable format. or I want your data, I want my data to be moved to another organization without obstruction. So let's say I had a pension, for example. I have the right to say that, you're going to move my pension pot and my pension data to this other organization, and you're not going to obstruct that by presenting the data in such a way that the other organization can't read it. And one of the things we use a lot in the UK is an open contracting data standard, which is an international standard, to allow for that data portability to be useful. And the final one is the one that you will hear most about if you spoke to someone in the UK about this, and that's the right to object. And this is a right to object to people using your data for a purpose you no longer consent to. And this predominantly pertains to nuisance callers, people trying to sell you insurance and such like. You have the right to tell that company you no longer want to be called and they must delete that data on you. But similar to what Joshua was talking about exemptions, the business of government needs certain exemptions on data subject rights. And when the EU wrote this law, they gave member states like the UK the opportunity to bring in exemptions to those data subject rights. And they surround things like crime prevention and regulatory activity or immigration control and judicial proceedings. Obviously, if someone is accused of a crime, they can't just invoke their rights to have their data erased. There needs to be provisions for crime enforcement agencies to conduct their investigations without those rights being imposed. And so what is this all about? Well, those exceptions aside, this is about enhancing trust with citizens. This is about giving users rights and powers in order to have more control over their data and for them to trust in organizations, both government organizations and private sector organizations, that their data is going to be handled lawfully and their data is going to be handled carefully and it's going to be handled in line with their best interests. And so what that means for organizations is they need a lawful basis for processing the data. The big one is consent. It's the most important one. It's one of the biggest changes in GDPR from previous regulations, and it's been beefed up considerably. The other one is contract. So if you're in a contract, but firstly on that one, you need consent to process your data. The second one is on contract. So if you're in a legal contract, you obviously need data to process that. The second one is legal obligation. So if you're legally obliged to hold that data, obviously that is a lawful basis. Vital interests, so protecting someone's life, vulnerable adults or children, or a public task where there is a clear public interest. And finally, if there is a legitimate interest for doing so, that also constitutes a lawful basis. But let me talk about consent, because that is a really key one with GDPR, and I've talked about nuisance callers. So alongside GDPR, there is a privacy and electronic communications regulation. And this is all about contacting people. And I've talked a lot about nuisance callers, but it also is something that is, which is something you get in the private sector where people are trying to sell you stuff and call you all the time. But actually, this is also something which applies to state sector organizations. So we have to be mindful of this too. If we don't have one of the other legitimate reasons for processing your data, state organizations also require that consent to be able to process your data. And what do we mean by consent? Well, it has a really high standard. It is a proactive opt-in under GDPR. Before GDPR, you could be opted, you could basically have an opt-out system. So before GDPR, you could be put on a database and you would have to opt out proactively to do that. But now with GDPR, you have to proactively opt in. So there's no more of these tick boxes that are already ticked on your behalf that you have to untick. You have to tick in to any data that you want to consent to if one of those other lawful aims of data processing are not present. And so that consent needs to be absolutely explicit and clear when that consent is being taken. And government organizations have to use their data controller to ensure that they are taking that consent and taking it clearly when they're processing data that doesn't have one of the other legitimate aims for processing. So in summary, this is one of the big changes of GDPR. It's around consent. It's around you having to positively opt in and being clear and explicit. And also finally, on part of this consent, you're able to withdraw it at any time. So if I decide that I no longer want this organization to process my data, I'm then entitled to withdraw it, and they have to comply if they don't have one of the other legitimate aims of processing. And of course, much like the data rights, there are exemptions to the legitimate aims. So again, crime prevention, protecting children and vulnerable adults, increasing diversity in the boardroom, and a number of other activities where there is a substantial public interest. And this is all key integral parts of the GDPR legislation, which allow member states, and in this case, the United Kingdom, which has left the EU but still keeps that regulation in place, has the ability to add exemptions to ensure that the business of government can continue. And so let's talk about what happens if you don't comply with this law. And I'm just picking up on Joshua's point about sort of legal proceeds, civil cases that you were talking about, or arbitrations that happen at present in Indonesia. So that was actually the case in the UK prior to GDPR. So under what was called the Data Protection Act of 1998, you would have to take someone to court if they'd violated your data rights. Where now we actually have a government regulator called the Information Commissioner's Office, who can find departments who you complain about. So we have a government regulatory body who enforces this legislation on behalf of individuals and citizens as a whole. And the penalties are quite severe. If an organization fails to meet GDPR rules and they are cautioned about it by the regulator, and they fail to take action about it, in very extreme cases, the regulator can seize up to 4% of that organization's global annual revenue. That's not just their revenue in the UK, that's their revenue globally. They have the power to seize 4% of that under GDPR legislation. This penalty has really changed the way in which particularly private sector organizations handle data, but it also applies to state sector organizations, departments and agencies. So government agencies and government administration also could potentially face that penalty if they fall foul of legislation. So it's really changed everyone's attitude and brought everyone into that privacy by design, and it enhanced that trust by having that harsh penalty imposed by the regulator. And finally, something as well that I think Joshua touched upon and is highly sensitive data. So we do have categories of highly sensitive data where additional requirements are needed for processing these. And so these are special categories. They do include things like people's racial and ethnic origin, or health or sexual orientation is included in that. And here's the full list of them at the moment. So things like race, political opinions, religious beliefs, trade union membership as well, genetic data, health data, and data concerning someone's personal sex life and sexual orientation are considered highly sensitive data that have additional protections. And these are the protections that are applied, as well as those legitimate aims for processing the data which an organization must show. They also need to show that they have met one of these tests, that they have absolutely explicit consent. So they have evidence that person has demonstrated that they clearly want this data to be processed. Or in the case of, I mentioned trade union membership or religious membership, obviously religious organizations have an exemption to that. They are allowed to process the data of their own members, and believers, but the reality, but of course, they're not allowed to share that data with other organizations without that consent, and other reasons for this, like legal proceedings, or if you're a doctor for medical purposes and public health. And so that's really it in a nutshell. GDPR strengthens and has strengthened the trust that users and citizens have in organizations, both state and public sector, by really enhancing their rights and providing very sort of clear exemptions where it's required by the state, but enhancing their rights across the board, and really enhancing the consent that they have to give to private organizations to process their data, and public organizations too. And that has really enhanced the trust and increase that privacy by design feeling of all database services, whether they're in the private or the public sector in the UK. And that's, thanks for that. And feel free to ask me any questions, obviously. But as I've said before, DCMS are the policy leads for this. So I may defer some questions to them if I can't answer it today, but thank you very much for listening, and thank you.
Thank you, Tony, for your very clear and very interesting speech and presentation. Distinguished participant, we have heard about the experience about regulation law regarding the data protection and data transaction from both UK government and Indonesian government. Now we are coming to the Q&A session. We have 5 minutes left, so I believe there is only one or two question that can be forwarded to the speakers. So please, if you have any question or any suggestion or any recommendation from you to the speakers, please mention your name and your institution. If I take a look at my AHA slides, there is still no question from the participant, but I will wait for another 1 or 2 minutes. Apparently, still no question yet. Please.
Would you like me to answer?
Please.
Okay, so that first one about data created by Indonesians is valuable. Also, over the top services are borderless. Should Indians be implementing GDPR-like law? How UK GDPR is implemented? Look, it's really not for me to say. Hello, can you hear? Yes, it's really not. It's really not for me to say anything about what the Indonesian government want to decide in terms of their laws. What I would say is, certainly from hearing what Joshua said, that the core principles sound very similar in terms of the laws that are being considered here in Indonesia. And I've just shared, obviously, some of my thoughts about, some of my knowledge of what we've done in the UK. I think my steer is that always, by being clear with people about how their data is being used, you're going to build trust with them. And that's what we've done with GDPR. And I think just from what I've heard from Joshua, that's what's going on in Indonesia at the moment. So obviously I can't comment at all on what the Indonesian government should do. That's entirely up to them and up to you lot. But I would say that I can see encouraging signs from what Joshua said, is that we're considering those principles of ensuring user trust is certainly there.
All right, that was from Pak Setiawan Mauludi, I believe. So the next question is from Pak Tomo Sudrajat. What kind of your country policy to handle the biggest data breach fines, penalties, and settlements so far? What kind of the main obstacles? I think it's for you, Tony, please.
What I said about GDPR is that we have an information commissioner's office that process fines that can be up to 4% of global revenue, which is quite a hefty fine, potentially. I would say that and again, I might have to take this question away. I don't know the exact percentage, but I would say that in a large number of cases, it is unlikely that a fine will be issued immediately. What will happen is that the commissioner, the information commissioner's office, and various regulators will take action and will attempt to caution organisations about the way in which they're conducting their data management if they're not complying. However, for very serious breaches, fines are implemented. And in October 2020, British Airways was fined £20 million by the Information Commissioner's Office in the UK. So fines do happen, and they are serious, and they do send a clear message to organisations about the cost of non-compliance. And when those fines are administered as well, it also enables individuals to take private action. So in the case of airline data breaches, it then allows other individuals to take private action in addition to the 20 million that they've been fined by. So it gives, it really is quite a serious thing if there are major data breaches and they are taken very seriously, and it has serious consequences for the organization in terms of revenue.
Thank you so much, Tony. I think this is the last question that we can discuss this time, because we are coming to the end of the first session. So the last question is for Pak Dedi. Pak Dedi, highly appreciation for your sharing perspective to simplify 1,000 applications to less than 100. Mind to share a bit further advice to accelerate faster and better one data in government. Please, Pak Dedi. Hello, Pak Dedi. Is Pak Dedi still there? Is Pak Dedi still there? Apparently, Pak Dedi is no longer with us, or?
Yeah.
All right. If Pak Dedi is no longer with us, I would say that we can conclude this first session. I will just give a brief summary about this first session. We have heard the experience from our UK government counterpart and from Indonesian government about the data transaction and exchanges. And we have heard that this time, this digital age, we are dealing with the data transaction, which is getting more and more important. Data itself has become a very, very important commodity. But the question is, how do we deal in having the safest transaction and exchange of the data? This is big question mark. And in order to do this, we need to keep in mind that this data transaction in exchange is not only within our country itself, but also cross-border transaction. So we need guidelines and we need standards. And the problem is that this guideline and standard has to be compromised by all participants. Therefore, this will make us think that seems we need to collaborate and participate more in context, in diplomacy, in partnership among nations. I think that will be a short summarize about this data transaction and exchange from the law perspective and regulation. And I here very, very thankful, and please allow me to extend our highest appreciation and gratitude to our honorable speaker, Pak Dedi, Pak Joshua, and Tony Richard from UK government counterparts. And please, all the participants to give, I don't know how to do this, but please give a big applause to our honorable speakers using your icon probably. Thank you very much. And I herewith closing the first session, and I turn back the floor to Yosita as MC. Thank you.
Thank you very much, Bapak Gogor. We indeed have gained new perspective from Bapak Dedi, Mr. Richards, and Bapak Joshua today. Before we commence to the next session, I would like to remind everybody that the attendance form as well as evaluation form will be announced by the end of the next session. So, Bapak Ibu, please be there. Ladies and gentlemen, now we are really going to move on to the next session. In the session, we will have 4 panelists that will discuss about the best practices of beneficial data ownership in both Indonesia and in the UK. I would like to welcome Mr. Angus Berry, the Southeast Asia Product Manager, UK Government Digital Services, who will moderating us in the next session. Mr. Berry, the time is yours.
Terima kasih. Assalamualaikum, selamat sore, semoga kalian semua sehat dan bahagia. Saya mau memperkenalkan pembicara kita untuk our second session, and I'll switch to English now for them. So the first of our speakers is Charles Baird. So Charles started by studying history at the University of Oxford before becoming a consulting data architect for various different firms before joining us at the Government Digital Service. And he joined us just as we established the Data Standards Authority, which is our attempt to share data standards and effective uses of data across the UK government. So our panel today, the second panel, is really about the effective use of data in government. So I'd like to pass over to Charles to get us started on that topic. Thank you.
Good afternoon, everyone. Thank you for the introduction, Angus, and thank you to the other presenters today. I found all of your talks so far to be very enlightening. I'll be talking today about our data sharing journey in the UK government in a broad sense, in terms of what we're doing from the centre of government, but also specifically how we're using APIs to deliver transformation and about how we're optimizing with standards to drive consistency. Hopefully there'll be some time for questions at the end. So to begin with, on what we're trying to achieve. The UK government has got a vision for 2030 for digital data and technology to improve the workings of government, and better use of data is key to delivering this. To do this and to improve data exchange, it's necessary to fix the foundations. So all of these areas that I've bulleted here need attention. I won't read them all out individually, but there's a lot to do. We believe that the journey to better data exchange starts with standards and quality. And so the UK government recently set up a data standards authority to look at these foundations. That's the team where I work. These bullet points are just a selection of the categories we've scoped out. We scoped 16 in total at the beginning of our exercise, and we're doing work in each of these areas. As you can see, there's a lot to do. I'm going to just concentrate on a couple of these today. One key work stream is metadata, to improve the sharing and publishing of data. And we produced standards for the use of metadata earlier this year. Another is data quality. And we work closely with our sister agency, the Government Data Quality Hub, which is based at the Office of National Statistics. Data governance, or the management of data within organisations of government, is key to data exchange. And a key work stream for the DSA is the improvement of this governance around data sharing, putting in place template memoranda of understanding to enable departments to standardise how they make agreements on data exchange. Data management is also key. The department that the DSA sits within, the Government Digital Service, or GDS, checks government departments that spend on technology or services, ensuring that we're making the right supplier and purchasing decisions. But spend controls haven't historically looked into data in as much detail as we'd like. So we're improving this with updated standards and more guidance to departments. We're updating this right now with more information on areas such as how to improve supplier contracts. And next, we'll be looking at the service standard, which is the standard which departments are required to meet when producing new services in more detail to make sure that we're recommending all the right data practices as part of service assessment processes. At the same time, we're looking to improve data skills across government. For example, we've recently created this role for a consulting data architect at GDS. The pay and reward for these roles need to be right for them to be successful. We need to bring in people to government who have the right skills and understanding of this area. But we also need to build up the data competence and understanding of the whole civil service. Now, to start to get down to more specific examples, we believe that the standards journey starts with architecture and technology. And to that end, I'm going to focus on APIs today. Over the last few years, the architecture community has moved from building and managing large-scale IT systems that take years to build and you need a unique set of skills to operate them, to building more modular architectures like microservices that allow us to be more agile and develop iteratively. And perhaps you could even say manage our data in a more easy way. So we've seen this architectural shift to being data intensive and design simple. And we're also seeing increased use of APIs within government. And this is because of the transformation they can deliver. The purpose of this isn't to choose a specific technology or to land on APIs as some kind of magic solution to all our problems, but to improve data sharing at the foundations so that we can build better services for citizen needs. With APIs, government can leverage data held by different departments and reuse components to build those services with less overhead of time, less investment, and more efficiency, because departments aren't collecting and maintaining the same data sets. In short, APIs allow us to work with what we have. For example, we can integrate legacy systems with modern applications without any disruption, allowing us to transform legacy systems to support modern business needs. For example, real-time information exchange. We can also do this in a way that maintains system integrity. For example, by restricting the number of calls that can be made on the system, or by specifying limits on what data can be accessed and by whom. As a concrete example, take a recent service developed by the Department of Work and Pensions in the UK. This is a relatively simple service, didn't take a huge amount of engineering time, and it just checks if a citizen is entitled to collect a prescription from a pharmacy without a charge. This has replaced a pretty cumbersome manual operation, which cost the National Health Service £250 million a year in waste. So you can see that connecting departments via APIs leads to real efficiency gains. And this is a fairly simple example, but it shows that information held by one department can be of real value to another. So what's our role at the centre of government with regard to improving API use through government? We've needed to take a coordinating role in setting standards. This involved creating consistency using standards and guidance, improving transparency through an API catalogue, which I'll come back to later, better documentation, and regular meetings of the community of practice around APIs and data exchange. And this technology, this community of technologists and as much as possible with international governments has really driven our thinking around standards and best practice for APIs in particular and data exchange more generally. So we've developed and continue to improve standards for APIs in government, working with practitioners across the public sector. You can see on the screen the last version of our API standards, which were published this time last year in 2019, and we are currently working on version 3, which will be published in the next few months. We've produced guidance and around technical implementations of API programs and management. So getting really down to the specifics of how government departments can set up API programs and how they manage them internally with concrete examples and playbooks for best practice in this area. We do all this in conjunction with the actual data producers and consumers in government. We're very dependent on our communities of practice to get the best advice and the best information into this. Previously, we've held regular in-person working groups. Obviously, sadly, this year we've had to move these online, but we've still kept them very regular. Our data sharing journey started with standardizing documentation for APIs, so that APIs can be used consistently across government. Documentation is often not given much consideration. It's not the most exciting part of the engineering challenge of APIs, but it's crucial for successfully and consistently using them across organizations and across government. And as such, it's essential to data exchange. And good documentation for any service helps with transparency and discoverability. In terms of practical notes, we've created a specific domain registry for APIs, the api.gov.uk domain. Again, to create consistency and transparency, because consistent naming conventions make APIs and resources easier to locate, particularly now as people want to create scraper type tools that can find all government APIs. And finally, we've created a government API catalogue. to improve the transparency, discoverability, and reliability of government APIs. We're continually iterating this product to improve its capabilities, including integrating it with the internal departmental catalogs to improve both the information we display from them and hopefully their internal governance mechanisms. So to conclude, if I can take you back to the beginning, the idea that data is important comes from the need to build services that better serve citizens. To do that, we need data standards that allow better data exchange between the different parts of government. And one concrete example of that is the use of APIs to allow services to draw on data from different departments. We see our role at the center as empowering departments to use APIs more effectively, as well as data standards in general. And we work to develop those standards, enable communities of practice, and share guidance and playbooks to do just that. Thank you for your time this morning.
Thank you, Charles, for that really interesting presentation. There's a lot to summarize in terms of this, so I'm hoping we get into some more of the detail during the Q&A. But a couple of things I found very interesting was partly what you said about how this has followed the digitization of government services. So how at GDS we started with digitizing user interactions and turned to data later. And then just secondly, the point you were making about involving practitioners and how us at the centre reaching out to departments themselves. So we've got two more speakers, well, three speakers in two sessions. So the first will be Raditya Kosasi, who I'll introduce in a moment. And after that, we'll have Karabo and Steve from Open Ownership, who will be talking about a case study of effective use in government. So they're from Open Ownership, which works on beneficial ownership data policies. So we'll have them as a case study as a third session. But moving to the second one to give the perspective from the Indonesian side on the use of data and the effective use of data within government. And we've got Raditya Kosasi. So he studied law at the University of Indonesia. He had various legal roles since, but most recently he's part of the Asosiasi Praktisi Pelindungan Data Indonesia, and also works as the Associate General Counsel on data intellectual property and commercial as a group data protection officer for Gojek. Is that right, Raditya? For the
yes, correct.
Yes, just checking I got that right. Brilliant. Well, I'll take no more of your time. Very interested to hear your perspective. So over to you. Thank you.
Thank you, Angus. Let me share my screen. Can you see my screen?
Yes, thank you.
Okay, thank you. Okay, good afternoon, everyone. First of all, thank you very much for Kementerian Secretary Negara and also UK government for having me as one of the panelists. My name is Raditya Kosasi. I'm the chairman of APDI, or the Indonesian Association for Data Protection Professionals. And I'm also currently working as a DPO in one of the tech company in Indonesia. So I will share with you from my perspective on the effective and the secure data sharing. Maybe I will see it from the perspective of a private practitioner, but since I also have some interest maybe in e-government, and like a couple of years ago, I wrote the thesis about it. So maybe it's really good to maybe touch a bit on that point at the end of my presentation. And also I have some question maybe for Charles for his interesting presentations. So, okay. So this is the outline of my presentation. So I will start by the introduction to this association. So actually, this is a really new association, so just newly established during this pandemic. So I think that's one of the good sides. So we have spare time during this pandemic to establish an association with some of my colleagues. So the founders are some of the privacy lawyers and also the DPOs in Indonesia. And the goal for this association is as the association of the DPO here in Indonesia, because in the upcoming data protection law, we will start recognizing the concept of DPO. So it's quite interesting, and want to have like a workshop training, and especially to improve the knowledge and also the competency of the DPO in Indonesia moving forward. So Actually, I want to touch a bit on the Indonesian regulatory framework, but I realized some of the previous panelists already touched, I think, more comprehensive about this topic. So I just quickly run through this. So actually, I think the existing data protection law is the minister regulation on the personal data protection in electronic system. It's number 20 of 2016. So a bit of this regulation is still on the consent-based data sharing or data protection. So mostly it depends on the consent from the data subject. And when we are talking about data sharing, there's also a provision in this regulation that data sharing should be conducted in coordination with the relevant government institution and in compliance with the prevailing laws. I think the first point is quite interesting. I think the government initially wants to have visibility on the data sharing that is happening in Indonesia. But I think moving forward, and also as the previous panelists say, we need to move the barrier. We need to remove the barrier for the data sharing. So I think from my conversation with one of the government officers, I think moving forward, I think we need to coordinate with the government institution, but there is no requirement such as like a reporting to the government institution. So it will remove the barrier for the data sharing moving forward. And the personal data can be shared to the government institution for the purpose of law enforcement. So I think when there's a case of law enforcement, or maybe for the purpose of in compliance with the law, we as the private practitioner, or maybe our private organization, can also share data with the government. So, and also I think a bit one point that this regulation touch about the data security is this regulation require the electronic system provider to store the data in encrypted form. So what about the upcoming data protection bill? So it's I think we make a lot of progress in the upcoming data protection bill, and maybe as Pa Joshua previously mentioned, I think this is more GDPR-like regulation. So this new regulation will applicable to both electronic system and non-electronic system. This is different with the previous regulation that mostly applicable to the electronic data in the electronic system. And there are several new concepts like the personal data and specific personal data. Maybe if you see the specific personal data is same with like the sensitive personal data under GDPR, right? And also under this regulation, I think we will have the new concept of data controller and data processor, which we don't have in the current regulation. And then I think for the data processing itself, so previously the basis for the data processing is mainly based on the consent, right? But as Pa Joshua also mentioned, that moving forward, there's also other legal other basis for the data processing, like the performance of a contract, legal obligation, and vital interest, and other lawful purposes. And also in this upcoming regulation, there's also a requirement to appoint an DPO if you met a certain requirement or certain condition. So this is quite interesting as well, because we don't have this concept in the previous in the existing regulation. But I think this is quite an important concept to ensure that every organization has someone that is responsible for the data protection compliance in their organization. And there's also a provision about the cross-border data transfer. So the cross-border data transfer is can be conducted when there's like there's a several requirement. For example, like there's a contractual obligation between the between data subject and also the data processor, and there's also a consent from the data subject itself. So my next topic is about the data protection principle. When you want to share data, first, I think you need to understand the data protection principle itself. So there are a couple of main concepts that I think I think it will exist in the upcoming data protection bill as well. And I think it's very relevant to the topic of data sharing. First is the data minimization. So when you want to share data, right, people tends to share as much data as you can, because let's say you have this X amount of data, then someone wants to see your data, then some people tends to just share the whole data, right? But in fact, actually, you really need to see what is the purpose of the data sharing and what kind of data that they need. You cannot, if you don't need to share everything, then you just need to share a certain portion of the data that they need. Because I think when you implement this data minimization, it will also reduce the risk when you do a data sharing. And also the purpose limitation. When you do a data sharing, I think you really need to understand what is the purpose of that data sharing. And when you share data to the other party, you need to ensure that they limit the use of that data as well. So it should be clear what is the purpose of that data sharing. And also on the data retention, when you share data to other party, you need to ensure that they will delete or remove or dispose the data once they already finish with the purpose of the use of the data itself. So I think this is like one of the important points that you need to include in the data sharing agreement. And then confidentiality and security. I think there are a couple of ways to secure the data. I think previously in the previous session there's also a concept of using API, right? So I think I fully agree with that concept. I think that's one of the way to share the data securely, and I think moving forward we should use that. But I think first of all, we need to ensure that we really need to understand how to create a secure API to ensure that we share the data in a secure manner. And also the accuracy. When we share data, then there's also a question how we ensure the accuracy of the data, right? So I think it's also important to ensure that when you share the data and there's any update of that data, so you need to explain to the recipient, or you need to update to the recipient as well, so the data can be updated as well. What about the data sharing tools that we usually use as a private practitioner? So there are two types of tools, I think, the technical tools and also the legal instrument. I think for the technical tools, Charles has touched this a bit. I think there are API as one of the main tools that we can use for the data sharing. And also, I think if your organization maybe not get used to API or use other stuff, so at least you use like the other method of data sharing that is secure. So you need to like maybe like the server that is has certain security requirements, so you can share the data securely. And for the legal instrument, there are a couple of legal instruments that you can follow or maybe that you can use. I think one of them is a data sharing agreement, or maybe like the other type of agreement that contains personal data sharing clauses there. So there are the typical clauses that you have in a data sharing agreement is the objective of the data sharing, right? Why you have this data sharing, and then who is the data provider and who is the data recipient, because maybe you are the one who signed the agreement, but actually the data provider can be your affiliates, for example, or maybe other organizations. So it should be clear in that agreement. And then the data retention period, as I mentioned previously, data retention is something that's quite important. So you really need to ensure that the data, the recipient will delete or dispose the data once the purpose has been served. And what are the restriction? If you have certain restriction that you want to tell the recipient, then you need to set it up clearly in the agreement as well, because you are the one who collected the data. So when you share the data to other party, you need to ensure that the recipient also follow your policy or follow the consent that you obtain from the data subject, right? So it should be clear what are the restrictions as well. And also the data sharing method, like how you share the data security terms, how they should protect the data in their system, and also the data breach notification. So when you share the data, you also have some policy in your organization, right? Let's say how long do you need to notify the government institution or the regulators when there's a data breach. So you need to ensure that you have the same policy with the recipient as well. And also you can include the warranties and indemnities if you and the data recipient agree to include those. And I think for the data sharing, your organization should have the strategy on how to conduct a data sharing. And I think one of the most basic one is you need to implement the data governance and data security, because I think by implementing the data governance and data security first, you know where is your data, what kind of data that you store, how you store your data. So before you share it, you know how you properly store your data. And then the data security, I think it will be very useful. I think before you share your data, you need to ensure that you secure your data properly as well. So before you share the data to others, make sure you really implement this concept so you can ensure that you secure your data before share to others. And then you need to develop a data sharing checklist. So this data sharing checklist is like an internal checklist for your organization to make sure that you have the similar approach when you have data for when you share data to for one party to another party. So I think it will ensure that your people know, like before they share their data, what kind of thing that they need to assess. And then establish the legal instrument. I think this is something that you can work together with your legal department to ensure when you share the data, there's a proper legal instrument in place, like a MOU or data sharing. And then I think moving forward, since we will have a concept of DPO as well in Indonesia, I think it's better to appoint a DPO if your organization share data regularly or store like a lot of sensitive personal data. And I think the last point is quite interesting, because maybe this is one of the strategy that we can follow, but we need to wait for the government to issue this guideline. So in other countries, there are some like a data sharing guidelines or data sharing framework that is being issued by the government for the guidance of the people in that territory, right? So I think this is something that is quite important, and I think we are for the private practice, we are looking forward to get this kind of guidelines so we can follow that practical guidelines for the data sharing moving forward. So usually before we share the data, there are a couple of points that we need to consider, right? So first, like what kind of data that will be shared. So you need to know first the type of data. Then what's the purpose of this data sharing? Like who will receive and who can access it. So let's say you share data from your company to another company, right? So I think you also need to know, like from the company who will receive the data, who will access those data. I think especially when you share like a sensitive personal data, you really need to limit who can access those data. And then I think you also need to check whether you have the consent to share those data. If you don't have the consent, then I think you need to go back to the data subject and make sure that you get a proper consent before you share that data. Then how do you share the data to the recipient? It's quite important to discuss and agree with the data recipient on how you share the data, whether it's through API or maybe like through other secure method. And then lastly, I think you also need to be sure that the data sharing won't violate any laws or regulations. So yeah, in conclusion, I think the data sharing topics has been regulated under the Indonesian data protection laws, but I think there will be more comprehensive regulation moving forward, since we will have an upcoming data protection bill. And I think data sharing should be done in a lawful manner and secure method. And I think there are a couple of principles and guidance that you can follow for this. And I think your organization should implement a data sharing strategy to ensure that you have a similar approach between one data sharing to another, and also should comply with the law. You should appoint a DPO if needed, especially when your organization process high volume of data or share data quite regularly. And the last one, I think it is quite obvious that there's a need of the guidance from the government on the acceptable data sharing framework, and also like data sharing guidelines for the private organization. I think that's all from me, but maybe I want to touch a bit on the data sharing between the government institution from Charles, that I do agree. I think the use of the API, I think it's quite important. And the standardization, I think this is a very interesting topic, because I think we tend to, each of the government institution, they tend to collect their own data, and they use their own standard, right? So I think if they want to integrate those data moving forward, the question is what kind of standard that they use. So standardization definitely is something that is very important. And I think in Indonesia, there's already an initiative called Satu Data or One Data initiative under the Statistic Bureau. So I think this is an important project that we need to support. And I think one of the homework is we need to have a more robust regulation about like a data protection or data sharing between government institutions, because now what we have is more on the data protection within the private organization. It's not in the government institution. And I think moving forward, it will be for the purpose of the policy making purposes. I think it's important when the government have the data and they want to share the data. It's also quite important on the topic of interoperability of the data or the system. So they need to be able to share data between organizations, right? And I think one of the questions is whether the government institution should have their own DPO. I think that's one of the topics that we can discuss. And I think moving forward to help the government to improve the way they share the data, I think public-private partnership or cooperation is something that's quite interesting that we can done together between the private and the government to enhance the ability of the government to share data between government institutions. I think that's all, Angus. Back to you. Thank you.
Terima kasih, Pak. That was really interesting. And I think in particular how you connected the two sessions. So firstly, the points you made about how if you're going to have an effective data sharing, data protection regime, you need to have effective data sharing standards and methods behind it. There's been many examples, as we know, of data protection breaches where it's not by design, but it's just by people doing it by mistake because they don't have effective ways of sharing data, and therefore it's not secure and it gets out and it's a breach. Secondly, I was really interested in what you said about governance and who should appoint DPOs, and it harks back to some of the points made in the first session about whether the authority governing data protection should be independent or should be part of government. I think Joshua and Tony both touched on that. So Tony spoke about how the IPO is an independent from government and can investigate data protection breaches. So thank you for connecting our two sessions so well, Raditya, and I hope we'll be able to get into more of your points about digital transformation and data use in the questions and answers. Thank you. So to round off our speakers, we've got Steve and Carabo from Open Ownership. So they'll be talking a bit about beneficial ownership policy and its connection to these issues, both of data protection and data sharing across governments, because as indeed they'll explain, beneficial ownership data involves many different policy areas and requires effective data sharing between government institutions. As a brief introduction to them, so Carabo studied both political science and law at various institutions in South Africa and the Netherlands before acting in various product management roles in civil society, justice and journalism projects before joining the Open Ownership NGO, which works on beneficial ownership. Steve, meanwhile, graduated from the University of Southampton in computer science. He's had various software roles in civil society tech firms before joining Open Ownership as their technical lead. A great contrast of backgrounds there. Steve and Karabo, who's speaking first between you two?
Thank you so much, Angus. That would be me.
Karabo, great. Take it away, Karabo. Thank you.
Thank you so much, Angus, and thank you to the Government of Indonesia and the other organizers of this really important event. I'm going to attempt to share screen. Right, so as Angus has said, my name is Karabo and I'm with Open Ownership as a country manager. And I'm joined today in presenting by our technical lead, Steve Day. We are going to be doing, as Angus said, a bit of a case study of how data sharing intersects with a particular policy area, that's beneficial ownership transparency. In the presentation today, I'll first start off by saying who is Open Ownership and what we offer. We'll then be talking about Open Ownership's beneficial ownership data standard, and then rounding off by looking at some policy considerations for data protection and data privacy. First, who we are. Open Ownership is a global initiative which was formed and were formed in 2017 out of the UK Anti-Corruption Summit to build a global standard for publishing beneficial ownership information and to support governments to implement the technology stack to deliver. Since then, 2017, the momentum to commit to beneficial ownership transparency has increased. Now, over 90 countries have commitments to BO reforms and are implementing either sectorally through, for example, the EITI standard in the extractive sector, or are committing and implementing full economy central registers, as is the case in Indonesia. Open Ownership is currently providing implementation support to over 40 of these countries, including to the British Overseas Territories. Our work is defined by the development of 3 products, the first being the Beneficial Ownership Data Standard, which is an effective data structuring and sharing standard. The Global Register for Beneficial Ownership, which demonstrates effective data usage, and then our technical expertise to develop and deploy beneficial ownership disclosures. These 3 areas, or these 3 products, are very closely interlinked. In delivering our support, we describe beneficial ownership implementation as a journey, and the journey starts from what we see the point of considering a commitment to beneficial ownership transparency, right up to the point of publishing beneficial ownership data. Open Ownership provides technical support throughout the implementation journey. Our implementation support is guided by the Open Ownership principles, which are the gold standard for transparency company ownership data. The principles were officially launched yesterday on International Anti-Corruption Day. And what we've seen through the development of these particular principles based on the work that we've undertaken over the years in over 40 countries is that by implementing the OO principles, countries can build a comprehensive picture of who owns companies in their jurisdictions, and thereby unlocking the potential of beneficial ownership data to reduce corruption and ensuring that all businesses know who they're working with and encouraging sustainable inward investment. There will be a consultation on these principles early in 2021. A demonstration of how the OO principles can be practically used is Open Ownership recently conducted a rapid assessment applying the OO principles to the UK public persons of significant control register. and the UK is a global leader on beneficial ownership transparency. The rapid assessment of the UK PSC register demonstrates how the 900 principles can assist stakeholders to understand the strengths and weaknesses of disclosure regimes. Just to say that the UK, according to the rapid assessment, scored an overall B, which is a good grade, but we did identify that there's further work required on data verification, and this is subject to some of the amendments to the UK Companies Act upcoming. And then finally, on the policy and program side, we offer a number of products, including scoping studies, targeted reports and recommendations across the policy, law and systems to generate impactful BO data. The policy briefings and guides offer best practices in implementing beneficial ownership reforms. I will now hand over to Steve to talk about our beneficial ownership data standard, as well as other tech tools.
Thank you, Karabo. So yeah, that was a quick overview of what Open Ownership do and the way that we support countries. I'm going to talk a little bit about the technical work that we do, our data standard and our technical tools that support that data standard. So much like Open Ownership, we started building this data standard right from the beginning in 2017. And it's been something that we've been developing iteratively ever since. We're working towards a kind of a stable version 1.0 in 2021. But the data standard is already being used today, and we'll have our first countries hopefully publishing data under that data standard in the coming weeks and months. So what is a data standard? I've heard a lot of people use the term today, but I don't think anybody so far has really explained what it is. So a data standard is essentially a structure into which you can put your data. And the idea is that, I think as the previous speaker said, it's not much good if you're the only person that uses that structure. So if you use the same structure that everybody else uses to share your data, then that, it becomes much easier for everybody to use it, because it becomes a kind of shared language that everybody can understand. So at Open Ownership, we primarily want beneficial ownership data to be available and to be kind of interoperable around the world, because we think that's how you achieve the benefits of beneficial ownership transparency. So we promote this data standard as a way of kind of achieving that. On the left on this slide are images of the original beneficial ownership disclosures that you might see in the UK, the kind of the paperwork that discloses that data, which if you're not familiar with the system are quite confusing. But on the right hand side is an example of some of the equivalent BODs, the beneficial ownership data standard data that represent the same thing. If you speak BODs, if you understand the BODs language, then you can understand this data without having to understand the kind of context and the details of how the UK does beneficial ownership transparency. And that's the value, because once you understand it in one place, you can also understand it somewhere else. We can go to the next slide. So, as I said, we think that by standardizing data, we make it easier for everybody to use it. And therefore, it's much more likely to result in the benefits of beneficial ownership transparency actually happening. But it's not only because it makes data easier to work with, but also because once you have a single standard, a single structure that everyone understands, it allows a community of tooling and technical kind of software to arise around that data standard. So this slide has two examples of that. The first thing on the left is a visualization of some of the example data that's given in Indonesia's Ministry of Law and Human Rights AHU Online, their API for beneficial ownership data. We've built a tool which can draw diagrams from any BODs data. So MLHR's data isn't currently in the BODs format, but we can turn it into BODs, and then we can use this tool to visualize it and to get this kind of this picture of the network that the data is describing. And the benefit of this tool is that it's open source for one, and so it's available for anybody to use. But because it works with standardized data, it can draw the same diagrams of data from anywhere in the world, so long as it's in the same format. The second example on the right-hand side is a prototype corruption flagging or corruption risk flagging tool. So this uses beneficial ownership data standard and open contracting data, which I think one of the previous speakers mentioned is very common in the UK. And so it's linking beneficial ownership data with procurement data, with tenders and the applicants for the bidders for tenders, and using those two pieces of information to highlight corruption risks in the tenders. For example, there's an example there where two bidders who seem seem different, but once you have their beneficial ownership information, you understand that actually they're both owned and controlled by the same person. So they're essentially colluding, or they're trying to form a cartel to bid for this tender. And again, that's the power of having the standardized data, is that anywhere that you have BODS data and OCDS data, you can put your data into this tool and achieve the same benefits. And then finally, one of our other kind of key tech resources is our global register of beneficial ownership. So we take open data disclosures from around the world. Currently that's UK, Denmark, Slovakia, Ukraine, and several EITI projects. And we combine them into one database. This is a useful tool for people to search for data, but it's also, for us, it's somewhere where we've learned lots of the kind of important lessons that we've been able to roll into our own data standard. So that's things like the importance of good identifiers for companies and people, the importance of tracking how ownership changes over time, and also then being able to access the data in bulk. So as well as providing an API for individual records, being able to look at everything within a data set. This register that we run also republishes all of its data in our data standards. So we've taken all those different sources of data and standardized them ourselves. And this means that we're effectively a publisher of data ourselves. We're operating a bit like a government might that has a central register. And this means that we understand the challenges that publishers face when they're doing that publishing, several of which are also obviously privacy and data protection, which at which point I think is good for me to hand back to Karabo, where she can talk in more detail about our approach to some of those challenges.
Thank you so much, Steve. So in considering how beneficial ownership transparency intersects with data privacy, we realize that this is a really important issue to unpack and understand how it works together. In the first part of our presentation, we show that there's been an important momentum towards the legal frameworks requiring ownership transparency in over 90 countries. Now, with the rapid uptake of beneficial ownership transparency, one area that has emerged as a key area of concern is the issue of how does privacy get protected? This is because beneficial ownership data includes data about people. And the concern is that by publishing information of beneficial owners, this could interfere or threaten individuals' rights to privacy, as well as protection of their personal data. We must therefore ask, does beneficial ownership disclosure conflict with data protection and privacy? The first point to consider is that as with all rights, privacy and data protection, while important rights, are not absolute. Beneficial ownership data collection, disclosure, and retention can be done in a way which both upholds these rights whilst fulfilling important public interest aims, such as beneficial ownership transparency. Open Ownership, together with the B team, as well as the Engine Room, have produced a research report which documents in detail the way in which implementing beneficial ownership transparency can comply with data protection standards and uphold privacy based on international legal frameworks. I will talk you through some of the key points and findings of this research report. The first point is that countries take different approaches to balancing data protection and the disclosure of beneficial ownership data. But the general thread that brings together all these different frameworks is that data protection and beneficial ownership laws seek to balance two things. The first being the interest of the individual in controlling access to and the use of their personal data, including, for example, their identity details, and balancing this with the legitimate interest in the use of that data to fulfill various functions such as regulatory compliance or public policy or public interest goals. What we have seen is that where legislation expressly provides for the compulsory registration of information on beneficial owners, compliance with this obligation to disclose is consistent with data protection laws, as it falls within the lawful authority exception. While the use of consent or contract might be used in countries without a lawful obligation for beneficial ownership disclosure, data processing may be lawful even in the absence of a subject's consent or agreement via contract, if the company making the disclosure is specifically required to do so under a legal obligation. So, for example, under a legal obligation to disclose that very beneficial ownership data information. So what are some of the principles around the disclosure of this information? With the question on the legal basis for disclosing beneficial ownership data being addressed, we move on to the more practical how of disclosure can be appropriately done. Now, there should, one, be safeguards and limitations in how the disclosure is done, which are done in a way that doesn't endanger an individual's privacy and security. It's also important to note that there is no one-size-fits-all answer to this question. It must be done in a way that takes into consideration domestic policy frameworks as well as policy objectives. Some practical key factors to consider are the what, whose data, and how data is being published, and how exemptions can be applied in data disclosure of beneficial ownership data. On the what is being published, governments and companies, we recommend, should not collect and disclose data beyond the minimum of what is necessary to achieve their aim, or data which poses a significant risk of harm. Now, the risk associated with the different types of information will depend on the context of both the individual and the country where they reside. The second thing to factor is whose data is being published. Now, whilst in some countries there are strong arguments that disclosure should only apply to certain high-risk individuals or entities or sectors, it can sometimes be difficult to predict which of the thousands of trusts or companies might be of interest, particularly to law enforcement and investigators. In this case, investigating financial crimes is not always a straightforward process, which is tied to particular sector or high-risk individuals. And so the more data there is available to comb through by these investigators, sometimes this can be a better option. The next question that should be factored in a disclosure regime is how it is published. What can be done is limiting access to beneficial ownership data to those who can. In some countries, they've chosen to go with limiting access to beneficial ownership to only those who've got a legitimate interest. Now, obviously, this is sometimes quite difficult to define who has got legitimate interests. So some countries have opted with a different type of process. And that's a more practical approach to, say, allowing public access to certain sections of the data, whilst allowing competent authorities and other public officials to have much wider access to the data held by a particular government agencies. In this manner, a balance can be sought between providing enough information to allow the public to have meaningful additional oversight, while not disclosing the details that might significantly increase the risks of privacy violations. The final and perhaps most important point is how then to define exemptions to who must disclose their beneficial ownership data. Now, in creating exemptions to who may disclose beneficial ownership data, what we have identified is that it's really important to ensure that these exemptions are as narrowly defined as possible and only granted to those who can demonstrate a serious risk to harm and therefore are exempted from any disclosure requirements. The definition and the operation of these exemptions may prove to be the crucial element in achieving proportionality between disclosure and protecting data privacy. To end off with, I want to focus on two case studies of countries and regions who are implementing beneficial ownership transparency and balancing data privacy rights. The first is of the UK. And in the UK's compliance with beneficial ownership obligations, we have now found that the UK's PSC register is done completely in adherence to its data protection policies. How the UK has managed the balance is that in the UK PSC register, it includes, for example, the person's name, address for services, as well as their country of residence and a variety of other data. But the public-facing part of this register has a limited set of publicly available data, and that a screenshot of that is available on my right-hand side, probably your left-hand side. And for example, the public-facing part of the register excludes the full birth dates of the specific beneficial owner. And in this way, the rights to privacy are balanced with the obligations to disclose data. In EU member states, as with the UK, who have arguably got the most stringent data protection law, the GDPR, which has been spoken about a lot today. Again, their obligations to disclose beneficial ownership data are done in complete compliance with their data protection law. And so as EU member states are now moving towards public transparency of beneficial ownership data, it is being done in a manner which complies with GDPR. So to end off with, for jurisdictions who have both a data protection law as well as a law around disclosure of beneficial ownership, these two requirements under law can be both compliant with each other as well as consistent with the provisions of various data protection policies. So I shall end off there. Thank you very much.
Thank you so much, Carabao and Steve. I think it's such an interesting case study of a policy area where Indonesia and the UK are leading the way in beginning to address these challenges. Secondly, an area where there's clearly a lot of challenges in terms of how we both collect and publish and share this data within government. And also, of course, an example where the two countries are collaborating. So it's great to hear about the project. Well done, everyone, for us keeping to time as well, which means we've got plenty of time for questions. Maybe to keep answers relatively brief so we can get through as many of them as we can. Charles, the first one's for you. The question was about how in encouraging government data sharing and publishing, you strike the right balance between, to use the phrase of the question, sectoral egos versus transparency. So how do you work with departments to ensure that they have the right level of protection of their data versus sharing it either with the public or with other departments?
Sure, there's I think sectoral egos is a really good phrase. I'm going to use that in the future. But I think there's two parts to this question. One is that there is a tendency for departments to be quite jealous of their data that they have collected it. They have been running programs for years, decades in some cases, and they've got these huge data sets, and they're very jealous of keeping them. There isn't a simple answer to this other than engagement with them and to address those, to keep that in mind. We've spent a few months building kind of close connections on this project with some departments who are very advanced in the data they collect, and sometimes it's about showing them the value of sharing data with other departments. Sometimes it's about showing them that they can export their expertise, if you like, their being seen to be trailblazers in data sharing can be a good way to assuage a sectoral ego, if you like. The other side, which is about sensitivity or security of data, is can be a bit more crucial, because some of these government departments especially have got very sensitive data. If you're talking about citizen information, such as the Department of Work and Pensions holds, if you're talking about tax records that HMRC hold, health records that the NHS hold, this is all stuff that we need to be very, very careful about showing. And one of the things we've been trying to develop is a model which is endorsed by the UK's National Cybersecurity Agency, where there is a metadata standard which doesn't impact the security of a data set. So you can say, okay, we can share this information about a data set because the existence of the data isn't secret, it's the contents of it. So we have tried to build something rather than kind of a technical solution where you're looking at, oh, who's got authorization to view this thing. We're looking to kind of sidestep that slightly and say, okay, what data about this admittedly sensitive data set can we share?
That's really interesting. Thank you both for pointing out how it's a collective action problem and turning the question on its head and say not what we need to protect, but what can we share. Thank you, Charles. Raditya, I'm going to turn to you, and if it's okay, I'm going to ask you two questions at the same time. So one was about awareness of data protection in lower income and rural citizens in Indonesia. So in your experience, how do you think we can both understand what the perspectives of those people are, and secondly, how can we communicate their rights and so on under data protection law? So if you could comment on that, and then maybe also if you could briefly comment on the second question there about the private sector mining of personal data. Should we in government be afraid about this, and is there any chance the government can collaborate with the private sector to deliver those services. I thought you might have an interesting perspective on that, as you've worked on both sides of that divide. Raditya, please.
Okay, thank you for the questions. So I think for the first question, you're asking about the awareness of the data protection in the remote area or the rural area, right? So I think the gap is still quite big between the big city and the rural area in Indonesia. So I think we have to admit that also for the data protection, there's still a huge gap in terms of the awareness. And even I think even though you see people in this rural area, they're using mobile phones, they use a mobile application, they use those applications, but in terms of the awareness, I think it's still quite low. I don't have maybe a specific research to support that, but I think that's based on my observation. Why I said that? Because I think for some of the mobile application provider, I think the fraud cases in those areas is not because of there's a sophisticated hacking activity, but I think it's caused by social engineering. So for this mobile application, they still use OTP to authenticate the user, right? So the way these scammers or fraudster, they somehow they can access the phone number of the user, and then they call the user, and then they pretend to be someone who's coming from that mobile app operator or provider. And then they ask for their OTP, right? I think that's the most cases happen in Indonesia, and I think it shows how we are still it's still lack of awareness in terms of the data protection in the rural area, and even I think it's still happening in some of the big cities in Indonesia. And I think one of the biggest program on one of the most important program for the government is the digital literacy, to improve the digital literacy of the Indonesian citizens. So I think it's quite important, because I see when they do this kind of program, they also touch about the data protection awareness. So I think it's very important, and there's still a big gap. We still have a lot of homework, but I think it needs the cooperation between the government and also the private sector as well, because they're the one who get the benefit from the use of this mobile application, and the use of they're collecting a lot of data from these people. So I think it's also an obligation for the private organization to improve the awareness of the data protection in the rural area. And also relating to that, you're asking like how you can communicate that. So I think the government has some program to improve the digital literacy of the Indonesian citizens. But I think for the private organization, they can also play a part on this by regularly showing a message in the mobile app that is being used by all the Indonesian citizens that, hey, be careful of the scammers, be careful of the fraudster, don't give your OTP. So I think this kind of reminder, a simple reminder, but remind them to be careful with your data, right? So I think that's how we communicate that with the people in the rural area, and some of people maybe in the big cities. And then for the second question, I think private sector collected a lot of data, whether the government should be afraid. I don't know whether I'm the right person to answer this, because now I'm not part of the government, but I think the second part of the question is quite interesting. Is there any chance that government can collaborate with the private sector? I think there is. I think government has some initiative like the stimulus. I think now Indonesian government wants during this pandemic, they want to distribute like a support for the maybe SME players, right? And maybe like all people in that rural area, and they're using a lot of mobile applications. So I think they can collaborate with the private sector to find a way how to collect the data legally. For example, like because there are some application that is being used by a lot of Indonesian, and people are very dependent on it. So I think if government use together with the application, send a message to the user, hey, we have this program, and if you want to participate, then we need to share your data to the government. Are you okay with that? If the customer says okay, then they provide their consent, right? And the private sector can share the data to the government. So I think it's about the medium, right? So I think that it's also the obligation of the private organization to help the government on this kind of initiative. So I think the short answer is yes. So I think there are a lot of ways private and public can have a partnership on this kind of initiative.
Thank you, Aditya. So interesting to hear the private sector reflections on these. Too often in government, maybe we just speak to ourselves. So thank you. Very briefly, Stephen Carabo, to round off the session in the last 2 minutes, there was a question about the approaches to collecting sensitive data. So how you can collect through applications or through other user journeys this kind of private sector data. So if you just want to comment maybe on the beneficial ownership example, the different ways in which beneficial ownership data can be collected as an example. Just the last couple of minutes, thank you.
Sure. Shall I take this one, Carabo? I'll assume so, unless you jump in over the top of me. So I guess we tend to work with two main options. There are paper forms and digital forms. Usually we promote a digital approach because you have options for validating the data, for just ensuring that the data is of higher quality if you're collecting it digitally. And often that would be integrated into something like a business register or an existing system in some case that people are already familiar with, are already submitting usually kind of company information as well. So that would probably already be a government website. And that government website might be used directly by companies, by people, or perhaps by notaries or some other official like your accountant or someone like that. So in that sense, the trust, I think that the trust situation is quite strong. You generally, you have a legal relationship with someone who's submitting data for you, or you're doing it yourself directly with the government, and hopefully you trust them to follow best practices on security and those kinds of things. And yeah, it's being, it's a very specific form that's being kind of directed at you. So it's, exactly where your data is going, the purpose that it's being used for, and you can be given some quite specific kind of assurances about what that data is going to be used for as well. So in those senses, the consent that people were talking about earlier in relationship to data protection laws is quite easy to get, because it's easy to explain why you need that information. And yeah, obviously, it's likely that you will need to give information to the government to identify yourself, perhaps, that you might not want published. So you wouldn't want to give out your personal identity numbers or your tax identification number to everybody, but you need to give it to the government so they know who you are, so that they can kind of accurately verify your filing. So we try to make a distinction with that about the information that's collected versus the information that's published, and make sure that is clear to people who are submitting the data, which ones are which, perhaps putting them on separate forms, or putting the identification information up front, getting that, and then going into the declaration of the public information so that it's obvious which is which. Hopefully that's
Thank you, Steve. Yeah, that's really interesting. I think that directly answers the question. Thank you so much, and to the other speakers too. So we've come to time. So just to say from the UK representatives, thank you to all the speakers. Thank you to the Ministry of State Secretariat for co-hosting this event with us. And thank you to you, the listeners, for both your interest in the event and your brilliant questions. So I'll pass right back to you, Asita, to finish us.
Thank you so much, Mr. Berry, for moderating the panel, and for all the speakers for the insightful presentation. Ladies and gentlemen, we have to come to the end of this webinar. We would like to convey our gratitude for all the panelists, moderators, and all the participants for joining this webinar, and hope that we will meet again in the near future. Sekali lagi, kami mengingatkan kepada Bapak dan Ibu bahwa formulir kehadiran, evaluasi, dan paparan para narasumber sudah bisa diakses melalui tautan yang disampaikan pada kolom chat. Untuk pengisian formulir, kehadiran, dan evaluasi, kami akan buka sampai pukul 18.00 waktu Indonesia Barat. Dengan demikian, berakhirlah acara webinar hari ini. Atas nama seluruh penyelenggara yang terlibat, saya sampaikan terima kasih atas perhatiannya dan mohon maaf apabila ada kesalahan. Wassalamualaikum warahmatullahi wabarakatuh.
Terletak di jantung kota Jakarta, Kementerian Sekretariat Negara memiliki posisi yang unik dan strategis. Secara garis besar, Kemensetnek bertugas menyelenggarakan dukungan teknis dan administrasi, serta analisis urusan pemerintahan di bidang kesekretariatan negara. Sederhananya, kementerian ini membantu Presiden dan Wakil Presiden dalam menyelenggarakan pemerintahan negara. Terdapat 7 satuan organisasi yang melaksanakan fungsi-fungsi tersebut, yaitu Sekretariat Kementerian, Sekretariat Presiden, Sekretariat Wakil Presiden, Sekretariat Militer Presiden, Deputi Bidang Hukum dan Perundang-undangan, Deputi Bidang Administrasi dan Aparatur, dan Deputi Bidang Hubungan Kelembagaan dan Kemasyarakatan. Kemensetnek terus mengembangkan diri, menciptakan berbagai inovasi untuk menjadi kementerian modern, akuntabel, transparan, dan mampu menjadi solusi akan kebutuhan masyarakat. Segudang prestasi pun telah ditelurkan. Semua ini sebagai bukti bakti kami kepada negeri ini. Semua dimulai pada tanggal 17 Agustus 1945, momen di mana mereka yang berbeda disatukan dalam Indonesia. Dengan semua kekayaan di dalamnya, Nusantara memproklamirkan pembentukan sebuah negara. Untuk menjalankan roda pemerintahan, pada tanggal 2 September 1945, Presiden Soekarno membentuk Kabinet Pemerintah Republik Indonesia pertama. Dalam peristiwa itulah diangkat seorang sekretaris negara dan juru bicara presiden. Sejak saat itu, Kementerian Sekretariat Negara tumbuh sebagai jawaban atas kompleksnya administrasi dan ketatanegaraan. Terletak di jantung kota Jakarta, Kementerian Sekretariat Negara memiliki posisi yang unik dan strategis. Secara garis besar, Kemensetnek bertugas menyelenggarakan dukungan teknis dan administrasi, serta analisis urusan pemerintahan di bidang kesekretariatan negara. Sederhananya, kementerian ini membantu Presiden dan Wakil Presiden dalam menyelenggarakan pemerintahan negara. Terdapat 7 satuan organisasi yang melaksanakan fungsi-fungsi tersebut, yaitu Sekretariat Kementerian, Sekretariat Presiden, Sekretariat Wakil Presiden, Sekretariat Militer Presiden, Deputi Bidang Hukum dan Perundang-undangan, Deputi Bidang Administrasi dan Aparatur, dan Deputi Bidang Hubungan Kelembagaan dan Kemasyarakatan. Kemensetnek terus mengembangkan diri, menciptakan berbagai inovasi untuk menjadi kementerian modern, akuntabel, transparan, dan mampu menjadi solusi akan kebutuhan masyarakat. Segudang prestasi pun telah ditelurkan. Semua ini sebagai bukti bakti kami kepada negeri ini. Semua dimulai pada tanggal 17 Agustus 1945, momen di mana mereka yang berbeda disatukan dalam Indonesia. Dengan semua kekayaan di dalamnya, Nusantara memproklamirkan pembentukan sebuah negara. Untuk menjalankan roda pemerintahan, pada tanggal 2 September 1945, Presiden Soekarno membentuk Kabinet Pemerintah Republik Indonesia pertama. Dalam peristiwa itulah diangkat seorang sekretaris negara dan juru bicara presiden. Sejak saat itu, Kementerian Sekretariat Negara tumbuh sebagai jawaban atas kompleksnya administrasi dan ketatanegaraan. Terletak di jantung kota Jakarta, Kementerian Sekretariat Negara memiliki posisi yang unik dan strategis. Secara garis besar, Kemensetnek bertugas menyelenggarakan dukungan teknis dan administrasi, serta analisis urusan pemerintahan di bidang kesekretariatan negara. Sederhananya, kementerian ini membantu Presiden dan Wakil Presiden dalam menyelenggarakan pemerintahan negara. Terdapat 7 satuan organisasi yang melaksanakan fungsi-fungsi tersebut, yaitu Sekretariat Kementerian, Sekretariat Presiden, Sekretariat Wakil Presiden, Sekretariat Militer Presiden, Deputi Bidang Hukum dan Perundang-undangan, Deputi Bidang Administrasi dan Aparatur, dan Deputi Bidang Hubungan Kelembagaan dan Kemasyarakatan. Kemensetnek terus mengembangkan diri, menciptakan berbagai inovasi untuk menjadi kementerian modern, akuntabel, transparan, dan mampu menjadi solusi akan kebutuhan masyarakat. Segudang prestasi pun telah ditelurkan. Semua ini sebagai bukti bakti kami kepada negeri ini. Semua dimulai pada tanggal 17 Agustus 1945, momen di mana mereka yang berbeda disatukan dalam Indonesia. Dengan semua kekayaan di dalamnya, Nusantara memproklamirkan pembentukan sebuah negara. Untuk menjalankan roda pemerintahan, pada tanggal 2 September 1945, Presiden Soekarno membentuk Kabinet Pemerintah Republik Indonesia pertama. Dalam peristiwa itulah diangkat seorang sekretaris negara dan juru bicara presiden. Sejak saat itu, Kementerian Sekretariat Negara tumbuh sebagai jawaban atas kompleksnya administrasi dan ketatanegaraan. Terletak di jantung kota Jakarta, Kementerian Sekretariat Negara memiliki posisi yang unik dan strategis. Secara garis besar, Kemensetnek bertugas menyelenggarakan dukungan teknis dan administrasi, serta analisis urusan pemerintahan di bidang kesekretariatan negara. Sederhananya, kementerian ini membantu Presiden dan Wakil Presiden dalam menyelenggarakan pemerintahan negara. Terdapat 7 satuan organisasi yang melaksanakan fungsi-fungsi tersebut, yaitu Sekretariat Kementerian, Sekretariat Presiden, Sekretariat Wakil Presiden, Sekretariat Militer Presiden, Deputi Bidang Hukum dan Perundang-undangan, Deputi Bidang Administrasi dan Aparatur, dan Deputi Bidang Hubungan Kelembagaan dan Kemasyarakatan. Kemensetnek terus mengembangkan diri, menciptakan berbagai inovasi untuk menjadi kementerian modern, akuntabel, transparan, dan mampu menjadi solusi akan kebutuhan masyarakat. Segudang prestasi pun telah ditelurkan. Semua ini sebagai bukti bakti kami kepada negeri ini. Semua dimulai pada tanggal 17 Agustus 1945, momen di mana mereka yang berbeda disatukan dalam Indonesia. Dengan semua kekayaan di dalamnya, Nusantara memproklamirkan pembentukan sebuah negara. Untuk menjalankan roda pemerintahan, pada tanggal 2 September 1945, Presiden Soekarno membentuk Kabinet Pemerintah Republik Indonesia pertama. Dalam peristiwa itulah diangkat seorang sekretaris negara dan juru bicara presiden. Sejak saat itu, Kementerian Sekretariat Negara tumbuh sebagai jawaban atas kompleksnya administrasi dan ketatanegaraan. Terletak di jantung kota Jakarta, Kementerian Sekretariat Negara memiliki posisi yang unik dan strategis. Secara garis besar, Kemensetnek bertugas menyelenggarakan dukungan teknis dan administrasi, serta analisis urusan pemerintahan di bidang kesekretariatan negara. Sederhananya, kementerian ini membantu Presiden dan Wakil Presiden dalam menyelenggarakan pemerintahan negara. Terdapat 7 satuan organisasi yang melaksanakan fungsi-fungsi tersebut, yaitu Sekretariat Kementerian, Sekretariat Presiden, Sekretariat Wakil Presiden, Sekretariat Militer Presiden, Deputi Bidang Hukum dan Perundang-undangan, Deputi Bidang Administrasi dan Aparatur, dan Deputi Bidang Hubungan Kelembagaan dan Kemasyarakatan. Kemensetnek terus mengembangkan diri, menciptakan berbagai inovasi untuk menjadi kementerian modern, akuntabel, transparan, dan mampu menjadi solusi akan kebutuhan masyarakat. Segudang prestasi pun telah ditelurkan. Semua ini sebagai bukti bakti kami kepada negeri ini. Semua dimulai pada tanggal 17 Agustus 1945. Momen di mana mereka yang berbeda disatukan dalam Indonesia. Dengan semua kekayaan di dalamnya, Nusantara memproklamirkan pembentukan sebuah negara. Untuk menjalankan roda pemerintahan, pada tanggal 2 September 1945, Presiden Soekarno membentuk Kabinet Pemerintah Republik Indonesia pertama. Dalam peristiwa itulah diangkat seorang sekretaris negara dan juru bicara presiden. Sejak saat itu, Kementerian Sekretariat Negara tumbuh sebagai jawaban atas kompleksnya administrasi dan ketatanegaraan. Terletak di jantung kota Jakarta, Kementerian Sekretariat Negara memiliki posisi yang unik dan strategis. Secara garis besar, Kemensetnek bertugas menyelenggarakan dukungan teknis dan administrasi, serta analisis urusan pemerintahan di bidang kesekretariatan negara. Sederhananya, kementerian ini membantu Presiden dan Wakil Presiden dalam menyelenggarakan pemerintahan negara. Terdapat 7 satuan organisasi yang melaksanakan fungsi-fungsi tersebut, yaitu Sekretariat Kementerian, Sekretariat Presiden, Sekretariat Wakil Presiden, Sekretariat Militer Presiden, Deputi Bidang Hukum dan Perundang-undangan, Deputi Bidang Administrasi dan Aparatur, dan Deputi Bidang Hubungan Kelembagaan dan Kemasyarakatan.